Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hey there, I'm Angela Princewill.
And I'm Sherine Abdi.
And our topic today is imputing cash gifts as income. So, if you've been through a family matter and had to deal with property, you probably know that you don't have to share your gifts. So what's a simpler way to put it, Sherine? I guess
where they're excluded.
It's excluded, yes.
Yeah.
Gifts are excluded property. So when you're calculating your net family properties for purposes of equalization, you get to exclude your gifts,
from third parties.
Yes, you get to exclude gifts from third parties. So that's known and that's fine. But that the analysis doesn't end there, right? So for the reality for a lot of families is that they receive, a lot of families these days can't, with inflation, they can't make ends meet with their incomes.
Yeah, or some have actually been supported maybe entirely by family, maybe their entire lives.
Exactly. So in those cases, what happens when parties separate? Usually one person is saying, well, we were supported throughout by, his parents. We're just using parents as an example. Okay. It's not
They're just most
exclusively
common. Yeah. Parents, grandparents.
Yes.
They're the most common, people that would actually give gifts of money to support, like a continuous gift, I would imagine.
Yeah. And it's always shocking for the parents to realize that something that they've done out of their goodwill is now somehow going to be an obligation. So let me set the stage this way. So let's say I'm not going to use Jen and John today. What am I going to use? Okay, I'm going to have to use Jen and John because I can't think of anything else. So let's say we have Jen and John, they're married and they have, mom and dad that, support them. So probably because Jane and John aren't making enough to, meet those mortgage, car payments, and maybe, John's parents are comfortable and want to maintain a certain lifestyle for their grandchildren that maybe Jane and John's income cannot support. And so let's say, over the years, it's a 10-year marriage, and over the years, they've been giving them, $2,000 one month, $5,000 another month. And it might not even necessarily have to be a consistent amount, but it's an amount that's significant enough to support their lifestyle. And now there's a separation. Clearly, if you base support, including the money that, mom and dad give, John's not going to be able to pay support based on that because, he's not earning that much. But that's Jane's position. She's saying, we've been used to this lifestyle. It's gone on for long. And, what a surprise it is for people all the time to realize that it's even a thing. I think usually for the parents, they're usually very shocked.
Yes, because for them, it's quite unfair. Like, they're out of their own goodwill, as you said, using, never did they think that they would have a continuous obligation or that they could be found to have that obligation. And I think that's the concerning part for, parents. And something that, word to the wise, just so you're aware, is that this obligation could exist if you are, supporting your child or grandchild through cash means.
So that's, there was this case, where, it was a child, they imputed this income, the mother in this case tried to get income imputed to the dad for child support purposes, because she says, well, dad had always received gifts from his father. And in this case, the dad had like a chronic disorder and he just had an inability to maintain employment. And because of this disability, the father, grandfather was providing cash gifts to father and, in the form of a monthly allowance to allow them cover day-to-day needs and pay medical bills and, bought properties, things like that. It was always grandfather's intention for father to become self-sufficient. That didn't happen. And, now the parties are separated and the wife's now trying to impute income, and the trial judge, really did dismiss mom's request there for income to be imputed from that, and saying, the idea behind giving dad those monies was to enable him become self-sufficient, and it was more in the nature of trying to support him to become self-sufficient versus providing an extravagant lifestyle. So I mean, take that as you will there. I mean, I found that a little bit interesting that it was more because I think the judge tried to distinguish it as providing day-to-day needs versus extravagant. But Sherine, I'm sure you would agree that it's kind of subjective, right?
Oh yeah, but it's also a fact-driven test too.
Yeah.
You also recently had this scenario,
yes.
If you recall.
Yeah, I do.
And it was dad and mom, but mom had no actual employment here, but she was receiving gifts in the form of money from her parents overseas.
Yes.
And husband was working. But when it came to determining like child support obligations and support obligations, our position was that income should be imputed to her.
Yes.
Obviously her position was that it shouldn't. But you've recently had this case, so it's not something that doesn't come up often.
Yeah.
So
I actually thought so it looks like we have this more often than we realize, because I was actually thinking about another case where mom's a realtor, dad's also a realtor. They're actually both doing well, but grandparents always supported dad, and this has gone on for so many years, right? And so obviously that's our client in this situation, and so mom was the one like trying to impute income to kind of increase his income, which in this case, I mean, I don't know, as you said, it's a fact-driven exercise, but I could see it really working against our client in the sense that if that income is not imputed to him, then mom would have to pay him spousal support and child support, depending on how we figured out parenting, because we wanted a 50-50 arrangement. So that's still, to be determined how that plays out. But the point is there was this support consistently over the years coming from the parents. Parents obviously are saying, no, we just did this in the context of the family. And if that family is no longer together, we don't know if we would still be providing this. Plus, we're old. We don't have this, a limitless amount of cash. So we don't know if we can keep providing the support. So,
wow. So I guess
I don't know if there's any lesson to be learned there. I mean, I want to contrast it a little bit with another case where, the husband's parents gave financial assistance to the parties, in form of also helping them pay for their matrimonial home and, helping the husband start a couple of businesses, pay for kids' camps and private school expenses, and even the husband's legal fees. And, in that case, the Court of Appeal held that the trial judge was right in imputing income. So obviously the trial judge did impute income, and they found that it was appropriate in this case because of the substantial size of the gift and the regularity with which it was provided. So what the courts also distinguished here is that the gifts helped the husband in this case to establish a lifestyle that's well above the standard of living that he could have had during the marriage. So what the contrast, I guess, between this case and the one I spoke of earlier is one allowed them to live an extravagant lifestyle, whereas the other one was more to allow them have the basics. In my mind, I'm thinking, well, basics, what's basics, right? I feel like if basics,
I mean,
if
that's
you didn't
subjective,
have,
right?
Yes, if you didn't have that gift coming from parents, basics would have meant a much like something at the modest, poverty, maybe almost at the poverty line. So I guess if you have parental support to kind of just take you above poverty line, it's okay, and income doesn't get imputed, or but if they're providing funds, and in the vast majority of cases, it's usually parents providing a little bit more to give the children and their families a little bit more of a lavish lifestyle. But anyway, as we said, it's a fact-driven exercise.
Yeah, and touching on that, like maybe we could talk about the factors that the court may consider.
Yeah.
And whether or not how much to impute based on gifts.
Also, so besides whether or not they would impute,
Yes.
even we have to, there's also the analysis of how much.
So these are just some factors, one of which is the regularity of the gifts. So obviously how often, if it was just like maybe a one time or a very like, you know, like over the couple of years, let's just say maybe you've given maybe 2, 3, not substantial, significant gifts. I mean, it would be very unlikely in that circumstance for that to be, you know, considered as a imputation of income for that purpose. The duration of the receipts, whether the gifts were part of the family's income during cohabitation, that was again enwrenched in their particular lifestyle.
Yeah.
The circumstances of the gifts that earmark them as exceptional.
Yeah, I guess if it's just the occasional birthdays and things like that, then it's less likely to be imputed, I guess.
Yep, and whether or not gifts do more than provide basic standard of living, which you touched on.
Yeah, which is where I mean, it's the law, but I kind of always struggle with that condition, yes.
The income generated by the gifts in proportion to the payer's entire income. Do you want to touch on that?
Yeah, so, I mean, if there's no, I think I want to pass on this one because I feel like I'm adding a little bit too much of my own subjective
reasoning.
Yes, into the process. So no, I'm going to pass on that.
Another factor is whether the gifts are paid to support an adult child through a period of disability. Another factor is whether the gifts are likely to continue, and that's I would imagine a very big factor, because if they're just not going to continue, I mean, how likely is it that you're going to get that income imputed to that person on an ongoing basis?
Yeah.
And lastly, the true purpose and nature of the gifts. And again, it goes to if it was just for self-sufficiency purposes or for,
yeah. Again, that's another one that
that's
another one that I struggle with. Again, I don't want to sound like, too much of a troublemaker. I get the idea. It's nice to provide, some funds to get people beyond a certain lifestyle, poverty level. I guess none of us want families and children to suffer, and I appreciate that. But I also find it to just be a little bit of an artificial, at what point do we draw the line? Because maybe for the parents that are gifting here, taking, vacations every year to them might be a basic. It's probably what they brought up their children to expect as a given. And now their children can't afford that for their families. And the parents are stepping in and saying, no, we do see some benefits to, 2, 3 annual vacations, 2, 3 vacations every year. I mean, so we're going to support that. But yeah, I know. To you and I, it might sound extravagant, but maybe to them, it's like they see the benefit from a child development aspect. Anyway, you can tell that I do struggle with some of these factors.
Yeah, I mean, if you're in a difficult situation where maybe, your spouse was supported by their family and, maybe for employment income purposes, they're not doing so well. And obviously, you could benefit if that obligation for the gifts continues, or if you meet any of those factors, it's worthwhile considering, imputing income to them from the cash gifts that they do get.
I mean, the reality is the law is the law, right? So if we see a situation where there's been gifts coming in consistently, and we can see that when we do your financial statements. So for our clients, when we see, expenses, if we're seeing expenses of $20,000, but we're just seeing an annual income from our client and probably their partner of like $5,000 or $10,000, then, and we're not seeing a lot of debt, we would usually ask where this is coming from. And when we get that hint that there's been these continuing gifts, regardless about how we feel about any particular factors or any situations, it is our legal obligation to follow that lead. We will, if you're the recipient, if you're the person that would be receiving support, we will do our best to make sure that income that's received as gifts gets imputed to the other side, right?
Of course, where appropriate, makes sense.
Yeah, exactly. And obviously, if we're on the other side or if we'll
tell you your exposure.
Yes, we will.
We'll try to minimize that as best as possible.
Yeah, and we recognize sometimes, the parents want to talk to us and they're like, well, this is not continuing. Why do I don't have to continue? And I think what the I'll say grandparents don't understand in this situation is it's not really you per se. Like I know in a roundabout way, the order is kind of made kind of against you because you're the one providing the support, but it's really the child that they're imputing the income against. But regardless of how we phrase that, they understand that the child that they're gifting these funds to isn't making that much. And so somehow or the other, the obligation is on them to continue funding, lifestyle post separation.
Yeah, and I think the courts also levied that kind of consideration about putting such an obligation on a third party.
Yes.
And, being mindful of like whether or not it's appropriate, because it's not something that's just granted all the time.
Yeah.
So it is something that is fact-based and evidence-based driven. So, of course, they'll have to be
the circumstances. Yeah, the circumstances will determine. So we don't want to give the impression that, it's just you get gifts all the time. They've been giving you gifts every day this last 1 year to support you during the pandemic. And then just like that, they now have an obligation. So it's not necessarily like that, but it is something that we want people to be aware of. And, if it fits your particular scenario, then of course you should pursue it. We always advise you to talk to us and, give us a little bit more about your specific situation. And then we can tell you whether or not, it's applicable to your case. Anyway, that's it for today. Thanks for listening. And until next time, bye for now.
Bye.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.